Today we are going to discuss the subject consumer protection law, the laws dealing with the consumers other than the consumer protection law. That is what the subject we are going to see. This is the topic covered under certificate in consumer protection. Today's lecture is specifically devoted to deal with those laws which are governed under the Consumer Protection Act. That is equally important. To recall your memories, the Consumer Protection Act covers two major things. One is the goods purchased and the services hired. This Consumer Protection Act is the enabling legislation, but there are several other laws which are also, which are kept in mind for providing relief under the consumer protection law. The laws are broadly classified under procedural laws and the substantive laws. Procedural law means the laws dealing with the procedure to be followed. For example, the Civil Procedure Code is the law giving the procedure to be followed by the civil courts. This is the procedural law. Similarly, there is a law called the Criminal Procedure Code, which deals with which gives the details about the procedure to be followed by the criminal courts. So these are the procedural laws. There are substantive laws. Substantive law means the law that deals with the determination of the rights and liabilities of the parties concerned. For example, the Indian Contract Act. It deals with this agreement between the parties concerned. So it is a substantive law. This law deals with about the substantive rights of the parties who enter into agreement. Likewise, there are several number of substantive legislation. Today we are going to see which are those substantive laws which can be which laws can be taken advantage under the consumer protection law. So those are the laws we are going to primarily deal with. Let us come to take this one after the other. For example, as I said, the Indian Contract Act. The Contract Act primarily deal with the entering into agreement between the parties concerned. If the party fail to fulfill the promises, then definitely that will amount to the deficiency, violation of the terms of the agreement, and it will amount to violation of the deficiency in service also. So this is the Consumer Contract Act is one which is the deals with the determined the rights. Although it is a separate act, but if you the parties wanted to take relief on the Consumer Protection Act, they can come before the Consumer Protection Law, even though the violation is under the Indian Contract Act. Similarly, there is the other law called the Electricity Act. We the consumers, we consume the electricity, but the electricity, there are several problems faced by the consumers. Sometimes the excessive billing is made. Sometimes the electricity, the meters are not working properly. Even the short circuit. Under time, several problems are being faced by the consumer in relation to the supply of electricity by the electricity department. If we want a relief from the electricity department, can we come under the consumer protection law? The answer is yes. And we can see some of the case laws also. And similarly, the other laws also, the Indian Post Office Act is there. The Post Office generally provides the services with regard to delivery of the letters, money orders, and various parcels also. In the process, the Post Office also very often commits certain mistakes, errors, and also the person who avails the service in the postal suffers from by the activities of the postal department, can he get a relief under the Consumer Protection Act? The answer is yes. There are examples of cases. A letter is posted, it is not received by the other person. Can he come under the Consumer Protection Law? Yes. Similarly, the money order is sent. The money order is, instead of delivering to person X, it is delivered to Y. The person who has not received the money order to whom it is meant, can he get the relief under the Consumer Protection Act? The answer is yes. Therefore, that's what under the Consumer Protection Act he can avail the benefit. Similarly, Insurance Act is there. With regard to insurance, there are two types of insurance. One is the life insurance, other one is the general insurance. Life insurance deals with the life of the individuals concerned, and the general insurance deals with about the property, the insurance with regard to the property, vehicle, all those things are concerned. Now, when the process of insurance, can we get a relief when you have taken the insurance policy, life or the general insurance policy, and the insurance company is not providing the required relief, can the insurance holder can come before the consumer court for a relief? The answer is yes. Suppose a very specific example: a person has purchased the vehicle, and at the time of purchases, the dealer promised that the service will be provided timely and quickly. After the purchase of the vehicle, the dealer is not in a position to provide the services timely as promised. Can the consumer come before the consumer court, even though it is an offence under the offence under the Indian Insurance Act? The answer is yes. The consumer can come under the Consumer Protection Act, even though the violation is made in the Insurance Act 1938. Similarly, there is an act called Seeds Act. Seeds Act deal with the purchase, production and the sale and distribution of seeds by the concerned government department. And very of the farmers purchase the seeds from the concerned government department. And if the government department is failed to supply the good quality seeds, due to that, if the farmer is not in a position to get the good crop, can the farmer get the relief under the Consumer Protection Act? The answer is yes, because even though the violations and the Seeds Act. Similarly, there the Indian Postal Saving Bank Act there is an act called Indian Postal Saving Bank Act. This Indian Postal Saving deals with the post office also function as the postal bank also. That is, bank means it accepts money from the public and it gives the money back to the public as and when the customer is in need of it. So in the process, very often we feel that the post office, the money is deposited. When the customer wanted to withdraw the money, maybe due to the mistake committed by the postal employees, the customer is not in a position to get the money back. Can the customer who has suffered certain deficiency at the end of the postal bank offices, can they come before the Consumer Protection Act? The answer is yes. Their remedy is available in the Consumer Protection Act also. Similarly, there is a law called the Indian Telegraph Act with regard to, again, telegram is a essential services. For telegraph is used for a faster communication. Now we have the email and mobile, all those things are, but think of a situation about 20-30 years back, for emergency communication, telegraph has been extensively used for marriage purpose, for death, for communication about the death of the person concerned. Telegram was extensively used. If the telegram was not communicated timely, then the purpose is defeated. So therefore, for the failure on the part of the telegraph department to deliver the telegraph on time, can the person who would give can he have the relief under the Consumer Protection Act? The answer is yes, there are. There is a case on which a person residing abroad, he is sent speed post money order. As well, speed post money order has to be delivered within 48 hours. But in a case that we'll be discussing later, the postal department, the telegraph department took 1.5 months to communicate, to send that telegraph message containing about the postal money order. With the result, the purpose for which the money was sent, that the purpose could not be achieved. It was for a medical treatment of the family members. Due to that reason, the person has died for want of the financial assistance. Can the person get the relief under the Consumer Protection Act for the mistake committed by the telegraph department? The answer is yes. The person who is affected, they can go before the Consumer Protection Act for the mistake committed by the telegraph officers also. Similarly, Motor Vehicles Act is there. That all accident cases, whether it's a trail accident, this bus accident or all type of road accidents. Now, accident is very common in cities like Delhi, Mumbai. Accident is very, very common. Sometimes the driver may be on the wrong side. Sometimes the passenger may be on the side. Yet there may be several problems and all. So, for any loss suffered or injury suffered due to the improper driving by the vehicle owner or the driver, can the affected party have the relief under the Consumer Protection Act? The answer is yes. We are going to see the case laws also. Similarly, there is the Food and Adulteration Act. Now, the customer is entitled to get the food which is free from all defect without the adulteration and all. But today we know adulteration is very, very common. Even we are not in a position to get the free air also. even we are not getting the pure water also. That is the situation today. If the goods are if the food is adulterated, can the person get a relief under the Consumer Protection Act? The answer is yes. The answer is yes. He can come under the Consumer Protection Act also. Similarly, there is an act called Drugs and Magic Remedies Advertisement Act 1954. No, in the olden days, even now it is taking place in almost the remote villages and all. Some people they give treatment by way of the magical actions, which is by way of the belief only. But that is not permitted under the law. So the law has been passed by the Parliament, which prohibited any treatment given by way of the magic and all. But even now in the village level, you will see some sadhus and sannyasis, in the name of the magic they promise to they cure the particular disease, but at the end of it they are not in a position to record relief. Sometimes the patients are are dying also. So this, if any person who practices even now, who promises that he will provide the relief for ailing patients, then action can be taken under that particular act, and for that also relief can be had from the Consumer Protection also. That the objective of today's lecture is, if the mistake or deviation is done under the particular act other than the Consumer Protection Act, can the people have the remedy in the Consumer Protection? That is the main topic today. Similarly, there is the Essential Commodities Act. Now sugar is at acute shortage. The prices of the sugar is going up like anything, and if the traders are hoarding the sugar for various reasons, of course the trader can be arrested under the Essential Commodities Act. In addition to that, if you feel that the person is or the fair price shops, despite holding the stock, if they are not giving the delivery of the goods, can he go under the Consumer Protection Act for getting the relief? The answer is yes, because you are entitled to get a timely delivery of the goods also, and it is, even though it is put in the Essential Commodities Act, the remedies can be available in the Consumer Protection also. Similarly, there are the Indian Standards Institute Certification of Marks Act, which is called the ISI Act. The Indian standard, this ISI mark, if anybody sells the goods by making the false marking of the ISI standards, can we file a case against them? The answer is yes. If anybody sells the ISI mark without getting it from the concerned competent authority, then the case can be filed under the Consumer Protection also. Similarly, there is a Weights and Measures, Standards of Weights and Measures Act 1976, under this law that the no seller can sell the produce which is less than the specified quantity as per the Weights and Measures Act is concerned. Underselling, if anybody undersells, if they sell the goods which is lesser than the quantity prescribed in the act, then action can be taken in the Weights and Measures Act also. In addition to that, the relief can be availed under the Consumer Protection also. Here I would like to tell you, the Consumer Protection Act is the additional facility available or additional legal remedy available to the citizens concerned. Therefore, in law it is in addition to other legal remedies under the law. Therefore, a person can have the remedy under the Consumer Protection law or under the related law also, or he can avail the facility under the both acts also in certain cases. Similarly, there is a Prevention of Marketing and Maintenance of Supplies and Essential Commodities Act passed in the year 1980, which deals with the prevention of the black marketing and maintenance of the supplies. Again, if the customer feels that some of the traders are carrying out the black marketing activity, and if they feel due to that reason, if they are not they feel that they are not in a position to get the goods timely, then they can get a remedy under the Consent Act also. In addition to that, they can come before the Consumer Protection Act also for a remedy and all. Then again, there is a Bureau of Indian Standards Act 1986. This again the act which deals about the standardization of the measures are concerned, and the person can have the remedy in the Consumer Protection law. There are various laws also dealing with the substantive laws for which we can have the remedy under the Consumer Protection law also. Now let us take to some of the case laws on this subject. That will come to this thing and all. Now let us say what are the type of cases have come before the where consumer courts and all. Let us say Insurance Act. As I said, Insurance Act. This is the case of the Deoker Exports Private Limited by New India Assurance Company, decided in the year 2009, reported in the Consumer Protection Journal, page number 6. This is the case decided by the Supreme Court. In this, it has been said that it is about dealing with the fire accident. no insurance cover exists on the date of the accident. As per this is the judgment given by the Supreme Court. It is the case under the this Insurance Act, but even though it is the case based on the Insurance Act, but it has been taken under the relief has been obtained through the Consumer Protection Law. Under this case, the Supreme Court held that no insurance cover exists on date of the accident. On the date of the accident, no insurance cover exists if the insurance premium is not paid on that day. Claim is rejected. So, insurance cannot assume risk unless the premium is received. So, what is the court in that case held? The Supreme Court held, if the premium is paid on the date of the accident, then only the claim will be entertained. If on the contrary, if the premium was not paid on the date of the occurrence of the accident, then the person will not get any relief under this case. This is the remedy could have been obtained in the Insurance Act also, but for a quicker remedy, the party has come under the Consumer Protection Act. Case has been filed. Ultimately, case came up to the Supreme Court when the Supreme Court clearly ruled that if the insurance premium is paid on the date of the accident has occurred, then only the person will get the relief, otherwise he will get the relief. Complainant wanted insurance cover to be continued for a period 12/3/1988 to 12/9/1999, premium for 1 year paid on 26/8/1988. As per bar contained the section 64 VB Insurance Act, insurer could not accept request to grant insurance cover with retrospective effect from the date period to receipt of the premium. Actually, what has happened in this case, the insurer wanted that the insurance cover should be given retrospective effect. Retrospective effect before the relief should be given even before the date of the payment of the insurance premium. Then the court held that generally in tax matters and the criminal matters, the retrospective effect cannot be provided. That is in general principle laid on the principle and all. Because only prospective effect can be provided, relief can be provided. That's the things and all. So that is the point of this. So if the party, even the party wanted that the retrospective relief should be given, that is not possible. That is what has been held in this case. No premium paid for further renewal policy beyond 25/8/1999. Insurer cannot be held liable for loss sustained in fire accident. This is what. Then the second case is again life insurance. This is again general what type of the insurance matters. Sometimes the people know they suppress certain material facts. This is the Sapna Arora versus LIC of India, again decided in the year 2009, report in the Consumer Protection Journal, page number 588, decided by the Punjab Consumer State Consumer Commission. In this case, life insurance, it deals with the life insurance, suppression of material facts. Insured suffered from diabetics, mellitus type 2. Prior to filing the proposal form, not disclosed. So the fact that he was suffering from diabetes was not brought to the notice of the insurance company. Documents in support produced on record. History given by the insured himself, recorded in discharge of certificate. Can validity become basis of reputation? Actually, what has happened, he was suffering from the diabetes, but at the time of taking life insurance, this particular fact was not brought to the knowledge of the insurance company that he was suffering from the diabetes and all. Because in the life insurance, what the person has to disclose, what are the disease he is having, as per his knowledge. That is important. If certain disease in the body without his knowledge, then perhaps that will not a fault. But despite knowing that the person is suffering from a particular disease, then if that he is failed to bring it to the notice of the insurance company, or if he fails to disclose in the insurance proposal, then it will amount to suppression of the fact. And if the fact is suppressed, and later on if the death or loss or injury occurs to the person concerned, the insurance company cannot be held liable for rejection of the insurance claim. Therefore, what is the lesson we can draw from this case is, whenever we go for taking insurance policy, we have to disclose all material facts known to us to the insurance company by disclosing all in the insurance form. If it is not properly disclosed, then later on, if the report said that the cause of the death is found that the cause for the death is due to certain diseases which was not brought to the knowledge of the insurance company, perhaps we cannot get any relief. So therefore, we can take a lesson from this case. Now, this is again the Contract Act. So, also I said Contract Act. This is the case decided Lalita Devi and others was LIC again, decided in the year 2009. Report in the Consumer Protection Journal, page number 575, Rajasthan Consumer State Commission. It deals about the Contract Act. Insurance, reputation of the claim, contention, previous policy lying in lapsed condition not disclosed at the time taking a fresh policy. Actually, in this case, the person was already having a insurance policy, but it has lapsed. But the fact that the policy has lapsed has not been brought to the knowledge of the insurance company, then he has gone for the fresh policy. That's the thing. Previous policy lying in lapsed condition not disclosed at the time of taking fresh policy. Proposal form filled by agent. Relevant column left blank with the remark not applicable. Insurer should have either asked to fill up the column or have rejected the proposal on ground of incomplete information. Proposal submitted in 1999. Deceased died in 2002. Policy cannot be called in question in view of the section 40 of the Insurance Act. Therefore, that means insurance company is liable to pay compensation to the party in this concern. Even otherwise, claim cannot be refused in view of the section 19 Contract Act, which provides contract not voidable if party whose consent was so caused at means of discovering truth with ordinary diligence. Truth could have been discovered by insurers as complete the record available with the insurance company. Life assured under treatment for serious ailment not proved. Reputation of policy unjustified insurance life. Actually, what has killed? No, the insurance company was in a position to ascertain the fact from the lapsed policy lying with it. Because since the company did not go into the details of the matters given the lapsed policy, that has become the deficiency on the part of the insurance company. Accordingly, the insurance holder was given the benefit of doubt. In this case, he was given relief under this in this case also. Now again there is another case of the LIC again, LIC of India versus Chandrakala, again decided in their 2009 report in the Consumer Protection Journal, page number 296, decided with the Delhi Consumer Redressal Forum. Life insurance, concealment of material facts alleged. Deceased deliberately concealed, withheld material information regarding smoking habit and ailment besides his age. So he has the smoking habit. In addition to that, he has some ailment besides age, and he has not given his correct age also. No evidence produced to prove deceased a smoker, which led to the cancer. Then what has happened to the smoking led to the cancer. That's what the line of argument was, which led to the cancer. No definite evidence related to age given. Again, for age, no evidence has been given. Age given in ration card, not definite proof of age. Again, this is the Delhi Consumer Commission. It says that the age given in the ration card is not a definite proof of age. That's the one point. Insurer failed to discharge onus to prove concealment of mental facts, liable to pay sum assured with interest cost awarded. In this case, actually the benefit is given to the policyholder for two reasons. Number one, the age, even though there is a dispute about the age, and they said that the age given in the ration card is not the reliable evidence, number one. Number two, with regard to that concealment of fact that he had a habit of smoking and that habit of smoking led to the cancer, that was not proved by the court. Therefore, the benefit of doubt is given in this case to the policy holder. On the contrary, had it been proved that the cause for cancer is because of the smoking, continuous smoking, and if the person failed to disclose this fact in the insurance proposal, perhaps he could not have got the benefit of it. Therefore, again, what is the message we can draw from this case is all the material facts should be brought in the insurance proposal. That is what the point we can learn from this case. Again, this is the LIC of India Mirabai case, decided in the year 2009, report in the Consumer Protection Journal, page number 439 by the Rajasthan State Consumer Commission. Life insurance, suppression of material facts, deceased chronic patient of TB. Here, that was earlier he was this smoker which led to the cancer. Here it is about the chronic patient of TB. Remained admitted in hospital for TB treatment period to filing of declaration form. Before insurance policies was taken, he was admitted in the hospital and he was taking treatment. Facts regarding health not disclosed in proposal form, but the fact that he was suffering from the TB was not disclosed in the insurance proposal form. Reputation of the claim by the insurance, then the insurance company repudiated the claim on the ground that the fact that he was suffering from TB was not disclosed in the proposal form. Repudiation of claim by the insurance justified. Deceased knowingly and deliberately gave incorrect information. Therefore, the Rajasthan State Consumer Commission held that complainant not entitled to benefit of the Section 45 Insurance Act. However, keeping his health condition, he was given the ex gratia payment of 10,000 on humanitarian consideration. Legally, he was not entitled to get 10,000 rupees. On humanitarian ground, he was awarded 10,000 rupees only. Again, from all the insurance related cases, what we can understand is all the relevant facts must be disclosed in the proposal form, and we should not suppress any material facts, whether it is related to any particular habit like smoking or any treatment taken like for cancer or tuberculosis. All these material facts has been disclosed. If it is not disclosed, then definitely the policy holder cannot get any relief from the concerned insurance company. Now we are moving from insurance to Indian Post Office Act. As I said, now the postal department is subjected to say lot of criticism by the courts concerned, and the postal department services generally considered as not as a professional being served and all, because I have come across large number of cases filed against the postal department, and all 95% of the cases filed against this postal department gone against the postal department. Therefore, that's the one serious matter. We are taken only the latest cases are being taken here. In this case, this is about the Superintendent of Post Office versus Rakesh Kumar, decided in the year 2009, Consumer Protection Journal, page number 391, Jharkhand. This is the State Consumer Commission, Jharkhand. Postal services, speed post, misdelivery, letter delivered to someone else. Actually, in this case, letter is addressed to a person X, but it is delivered to Y instead of addressee. Misdelivery willfully committed by the postman. The most important fact is the postman deliberately, he knew that who is the addressee, but instead of giving it to him, he gave it to somebody else, which is a deliberate act. I mean, by the postal men generally they indulge in this type of activity, because maybe one fact that they have been paid very low salary, that was been one of the reason is being given in the court judgment and all. Because they have been paid the low salary, they resort to this type of activity. Very often the money orders are not being given to the right person. Normally, sometimes they swindle the money, or they give it to somebody else, or they share the money with others also. So misdelivery will be committed by the postman is concerned. No explanation for misdelivery given. Addressee denied to have received a letter. Deficiency in service proved. Protection under Section 6 Post Office Act not available. Actually, under the Post Office Act, there is a protection is given to the post office, which says that if the letter is if the proper address is given in the address, and if the letter is then it will be deemed that the letter is delivered to the person concerned if it is the ordinary post. So that type of protection is not available to in this case they said the post office not liable for certain acts, but that is a protection available in that case. They said in this case that protection is not available to the postal department in this case concerned. Liable to compensate for mental agony, and in this case the person who failed, who has been deprived of the letter, he has been given compensation by the court for the mental agony suffered, and the cost was also afforded in this case. The next case is Superintendent of Post and Telegraph Department Circle at Solan versus M.L. Gupta, decided in the year 2009, Consumer Protection Journal, page number 132. This is decided by the National Commission. In this case, postal services wrong delivery, deficiency in service on the part of the postal department alleged, delivery of postal articles to right address not ensured. Again, this is about the wrong delivery of the postal articles to other persons, which was not the concern, but it is the duty of the postal department to deliver the letters, parcels, or the money order to the right person only. If it is not delivered to the right person, whether it's a letter or a speed post or the money order, definitely it will amount to deficiency in on the part of the postal department is concerned. Generally, based on the review of the case law, has revealed that the post office maybe due to lack of this professionalism at their level, they are not in a position to provide the required service to the parties concerned, and they by and large they work on suspicion. They don't rely on the credibility of the person. Normally the poor people, they go to the post offices. By seeing their way of dressing, their look and appearance, they suspect the people concerned. Normally they are genuine people. Even then they have been denied of the benefit by the postal department. So there are a large number of, this is the one case about the postal department is concerned. Default and wrong delivery. Delivery of postal articles to right address is not ensured. Default and gross negligence on the part of portal proved. Pecuniary loss suffered by complaint. Protection under 6 Post Office Act not available. Complaint allowed by forum. Appeal against the order dismissed. No interference record in this case. Again, next one is the Department of Postal Post Shimla versus Nitin Paul, decided in the year 2009. Report in the Consumer Protection Journal, page number 20. This is by the Himachal Pradesh Consumer State Commission. In this case, postal service, speed post money order, delivery delayed by 1.5 months. This was I mentioned during my opening remarks. Delivery delayed by 1.5 months. Contention: money order reached late due to technical failure as satellite got locked, but no evidence produced in support of the above contention. See, it was the contention of the postal department that due to satellite problem that the communication could not be communication could not be received timely, but they could not produce evidence towards the fact that there was the failure of the satellite failure. Because of that reason, the postal department lost its case, and international. As it supported the above content, international delay caused by postal authority in transmitting speed post money order. Again, as per the postal department, the postal letters, the speed post should be delivered within 24 hours to 48 hours within the country, and from anything received from foreign countries, it should be delivered within 64 to 72 hours concern. In this case, there is a delay of 1.5 months, which is a serious cause of concern. So then again the postal department started taking defense under the Indian Postal Act, that's section thing, but the court said the defense is not available to them, therefore the person was given the relief under this act is concerned. Now we are moving from Indian Post Office to the Indian Postal Saving Bank Act. There is an act called Indian Postal Saving Bank Act. And here again the difference with the previous, that was the previous act dealt with only the postal letters, all those things, letters, parcels, and all other things. This is the act dealing specially say postal saving bank activities only. That's the difference between the previous act and this act. Indian Postal Saving Bank Act section, banking and financial services, national savings scheme, joint account opened against rules and regulations. Actually, as per the rules, and the NSS National Savings Service Scheme cannot be opened in the joint names, but the postal authorities advise the concerned parties to go for the joint account. So, joint account opened against the rules and regulations. Suggestion given to complainant to close the NSS account and open new account in individual name. Not wrong. The complainant wrongly allowed by the forum. What is prohibited under the rules and regulations cannot be allowed to be continued. So, under the rules and regulations, it is totally prohibited that the joint account cannot be opened under the NSS scheme. But even though the advice is given by the postal department that since it is amount to violation of the rules and regulations, and they have taken it, they said that the postal department would not get record relief under this act is concerned. Now we will move from the postal saving bank account to other cases with the Indian Telegraph Act. Again we will see some of the case laws under the Telegraph Act also. In the Telegraph Act also, as I said, we have discussed the telegraphs now in the earlier about 40 to 50 years, even 20 to 30 years back. Telegraph has become a very, very important mode of transmission of the communication period to the 1980s, and for all important messages, telegraph is being extensively used. So this now we are going to look into the what type of cases thus come before the consumer courts under the Consumer Protection Act. This is the Bharat Sanchar Nigam was limited under Shriram Avasti, decided in the year 2009, report in the Consumer Protection Journal, page number 345, again by the Himachal Pradesh State Consumer Commission, Telegraph Act, section 7. Telephone bill excessive, sudden spot in meter reading found. Telephone not kept under observation. prescribed procedure and guidelines not followed by the department, deficiency in service proved. Printout placed on the record shows only the STD calls have been made, local calls not shown. That is the evidence that in the from evidence. Printout not to be relied upon. This is again the printout placed before the court is not to be relied upon. Complainant allowed by the forum or upheld in appeal. So here what is the case? The telephone the telephone not kept under the observation as per the act. The telephone should be kept under the observation. But that is not kept here. Therefore, the matter has gone against the department. In addition, that photocopy has been kept in the record, but the photocopy should not have been kept. It is the original document should have been kept in the record. These are the two things that has gone against the concerned department, Bharat Sanchar Nigam. However, the case is brought under the Consumer Protection Act, and the relief is given to the consumer concern. Now we are moving from Telegraph to the Seeds Act. Again, I made in the reference in my opening remarks that it is the government, the agriculture department generally supply the seeds to the farmers. And in this case, what has happened? The seeds. There is an act called the Seeds Act 1966, passed was there. As per the act, the state, it is the duty of the state government to provide supply seeds, good quality seeds to the farmers. In this case, seeds defective. The seeds supplied by the government department was found defective, uncertified, and it was not certified also, and sold to the customer, to the farmers with wrong representation. But in addition to that, they made a false claim that the sold with wrong representation, that the seeds were certified and having 80% germination capacity. Number one, the seeds was defective, it is uncertified, but at the time of sale, the department claimed that the seeds were certified and having 85% germination capacity, and the procedures, sellers of the seeds legally and ultimately then later on it was found the seeds were defective, and with the result the farmer could not get the record the quantity of crop from that particular the area. Now this in general, it was held that the seller of the seeds legally bound to get reliefs, get seeds certified under the Seeds Act. So the relief has been given by the consumer court to the farmers who have suffered because of the improper sale of the uncertified and ungerminated seed to the farmers concerned. So this is under the Seeds Act. So from the now we can take a look what type of things are covered. One is the services. Postal is a service, telegraph is the services, and the electricity is a services. Now we have come to the goods also. Goods all we have, because Consumer Protection Act deals with the goods and the services. So we have taken one example. The seeds is the goods, whereas the postal is the service, telegraph is the service, electricity is the service, banking activity is the service. These are the things are concerned. Now we will see other acts also. The seeds sown found to be uncertified and having low germination capacity proved by the report of the enquiry committee. Low germination capacity. See, the enquiry committee was appointed in the previous case, and the enquiry committee come to the conclusion that the seed supplied was not fully germinated, and the fact was admitted also again, and the relief was given to the farmer concerned. Now we are coming to the another important Motor Vehicle Act, which is again accident matters. Even though the accidents, there is a Motor Vehicle Act to deal with the accident matters, but still cases can be brought under the Consumer Protection Act. Let us see some of the cases under the Motor Vehicle Act. New India Assurance Company versus Geeta Devi, report decision the year 2009. Report the Consumer Protection Journal, page number 325 by the Jharkhand State Consumer Commission. Insurance, driving license, validity. Driving license in lapsed condition at the time of accident. At the time of accident took place, the driver had the license but which was lapsed. Then reward after accident. Person continues to duly license. No, this is a renewal after accident, but he renewed the license after the accident took place. So, sorry, there is a spelling mistake, typing error. Renewal. He renewed the license after the accident has taken place. Person continues to be duly licensed, subject to his obligation to get the license renewed after the period of its effectiveness. Genuine license, if expired on the date of the accident, renewed later, would be deemed valid and effective on the date of accident. This is a very, very important ruling given by the Jharkhand. I will repeat it for all the benefit of all. Persons continue to be duly licensed, subject to his obligation to get the license renewed after the period of its effectiveness. Genuine license, if expired on the date of accident, I would like to repeat it, if the license is genuine and if it is expired on the particular date of accident, and if it is renewed later, even then it would be deemed valid and effective date on the date of accident only, because maybe due to overwork, due to paucity of time, the person would not have got time to go before the concerned authority to renew it, but his ability and capacity to drive properly, that remains intact with him. Therefore, because of this reason, for some various genuine reason, if he is not in a position to renew the license on a particular day, and by some accident occurs on that particular day, that does not mean that the person has committed a mistake in the law. So the law is given the consideration in this case. Driver not disqualified from holding driving license. Insurer held liable to pay repair expenditure with interest, compensation deleted in appeal. So actually this is the case where the driver was not disqualified from holding the license for the future period. I mean, it's a very important case where we can mind, for one reason or the other, it is advisable that before the expiry of the license period we should renew the license. But if it is not in a position to renew it on the date of the timely, and if the accident occurs, here is a case where we can take the benefit of this case also. Then Rajendra Kumar Maurya versus Oriental Insurance Company Limited, decided in the year 2009, report the Consumer Protection Journal, page number 245. This is the Chandigarh State Consumer Commission. Motor Vehicles Act 1988, section insurance, driving license validity. Driver holding license to light motor vehicle. The driver on that particular was holding the license to drive light motor vehicle, but he was driving goods carriage. That is what the heavy vehicle. At accident time, complainant consciously allowed a person to drive goods carriage for which he was not authorized. Here, see the difference between the previous case and this case. In this case, the person was having only this light vehicle only, LMB, the license to drive light motor vehicle, LMB only. But despite knowing the fact, the owner of the vehicle, despite knowing that he is having the LMB license, he allowed him to drive the heavy vehicle, which is not permitted under the, which is dangerous also. Therefore, because of that reason, deliberate act on the part of the lorry owner or the owner to allow the driver who is having the light vehicle license only, allowing him to drive the heavy vehicle, definitely amount to serious offence, and under the law, in any case, he will be eligible for the criminal punishment. In addition to that, the case has been filed on the Consumer Protection Act, and the case is taken into cognizance of, and the person the person who has been affected by the accident has been given the benefit also. At incident time, complainant consciously allowed a person to drive goods carriage for which he was not authorized. Terms and conditions of policy violated, insurer not liable under the policy, no relief is entitled. So therefore, if you allow any person to drive a vehicle without having a license for that particular vehicle, that will amount to violation of the law, and the relief can be obtained under the Consumer Protection Act also. Then this is again Kailash Chandra versus Orient Insurance Company. And then motor accident claim repudiated, content driver not having license to drive LMV vehicle, contention owner under bona fide belief that the vehicle in question, light commercial vehicle, terms of insurance policy not violated. Actually, in this case, it's a different type of case. The driver not holding license to drive LMV vehicle. The driver was not having the LME vehicle, but the owner believed that he was having the license. That was the bona fide missing. Owner and the bona fide belief, he honestly believed that the person was having the LME, the license only, because it's, if any mistake is the bona fide one, then definitely the law will take cognizance of it. So these are some of the cases. There are large number of cases which you can come to the electricity also. There are cases under the Electricity Act that we can, again, if the electricity is not supplied properly, or if there is any defect in the meter reading and all, those type of cases are also covered under this. So by and large, now we have seen it. All the acts we have seen, these are the different substantive laws, like all the enactment we have seen, 15 or 20 enactment. But even though they are the law is a different nature, but the relief under all the other substantive law discussed so far, we can have the relief under the Consumer Protection Act. So in other words, we need not look for the relief under all the respective law. For all the enactment, the relief is available in the Consumer Protection Act if it is related to the supply of goods and services, and the person who purchases falls in the definition of the consumer. with this a few remarks on case laws, I'll conclude this lecture, and in the future we'll look on we will take some other case laws in the subject, and we thank you one and all for hearing us. Thank you very much.